So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. We're going to be talking about a new law that's coming fresh out of Springfield, Illinois, from the Illinois General Assembly. This law has been signed by Governor J.B. Pritzker, and it's criminalizing wage theft in many ways, but I find it quite curious. There's a few stipulations that we're going to talk about and discuss. So, Illinois Wage Theft Bill HB 1122 was one of the top priorities of the state AFL-CIO. And I honestly racked my brain to figure out why. The AFL-CIO is, of course, a group of unions, sort of an umbrella organization of such. But this bill predominantly focuses on freelance contractors and is unlikely to unionize. Now, of course, wage theft is important and all people should be interested. But what sort of vested interest AFL-CIO has in this, I'm not quite sure. The Illinois Senate agreed 35 to 20. Illinois House passed it 68 to 38. And it specifically surrounds, again, freelance workers and mandating their employers sign them to written, legally enforceable contracts with wage protections. It makes employers or companies who are contracting out freelance work pay in a timely manner. They have to pay within 30 days, which I'm curious if that will disrupt any payment processes. Many companies have like a net 90 and so forth. And so to take on a freelancer will now require immediate payment or payment within a month. And that changes things. In addition, it provides that no hiring party shall threaten, intimidate, discipline, harass, deny a work opportunity to, or discriminate against a freelance worker, or penalize or take any other action that penalizes freelance workers. It seems like it will cause quite a bit of headache. Some of this stuff is, good things, although quite frankly, freelance workers typically would take their contractor to, they would typically take them to a small claims court if they hadn't been paid. I don't understand why this is any different or how this makes the process better or quicker. But it does require written contracts for services or products provided by a freelance worker. And in the written contracts, it must include or must retain its contract with a freelance worker for no less than 2 years and must make the contract availability to the Department of Labor upon request. And what I get the impression, if I had to summarize this, is that all of these things are good things in theory, but I don't understand how people who want to use freelancers and freelance work is often done by people who are not typically highly compensated. But it would discourage businesses from using them if they're required to maintain contact, required to pay on a net 30 basis instead of a net 90. And perhaps that's what the AFL-CIO is attempting to do here, right? Maybe that's why they are interested in pushing this, because it pushes out the idea of freelance workers and pushes people who would be freelance into positions at the AFL-CIO, or at least covered by the AFL-CIO. They've created such a just a entanglement of legal responsibilities on businesses who are simply, using freelance workers to achieve goals without any long-term relationship. And as a result, these freelance workers were able to operate how they like. But this seems like it's going to, change that relationship, and as a result, potentially change their income. And again, I guess that's the goal of the AFL-CIO. I really don't know what they're looking at. But it requires the Attorney General to initiate or intervene in a civil action if the Attorney General has a reasonable cause to believe that any person or entity is engaged in a pattern and practice prohibited under this act. In addition, it requires contracts for products and services of freelance workers, removes a provision that requires each party to the written contract to retain a copy for a period of 2 years after the products or services are provided. And for me, this just reminds me of Assembly Bill 5. Assembly Bill 5 was a bill out of California that was aimed at Lyft drivers, Uber drivers, DoorDash, etc., but ultimately started hitting, unrelated people, right? It started hitting people who were singing at bars, making them employees of the bar, even if they were just playing for a night, right? And this smacks of that. It smacks of unintended consequences all the way down the chain, such that normal people who were quite happy with their relationship with businesses are hurt and affected. I guess we'll see what's going to come out of this. This assembly, this HB 1122, has a lot of knock-on impacts that I don't know if the writers fully understood, and that will be for us to watch and maybe laugh at. Let me know what you think in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.